Imagine living in a world where doing the right thing is sometimes the most dangerous choice. A world where if you follow the law, you might get into trouble, but if you do the wrong thing, the law gently pats you on the shoulder and says, "It's okay, I understand." Sounds like a dark comedy movie, right? Unfortunately, this isn't a movie. This is real life. In this world, your house may not truly belong to you. Silence can be more valuable than the truth. And sometimes the person who did wrong is protected more carefully than the one who did right. So the big question is this in the end, who is the law really made to protect? Story 1. When the intruder gets injured and the homeowner goes to court, the story begins with a bold but not very smart choice. A man decided to break into a house that was not his at night quietly and full of confidence. Unfortunately, the staircase inside the house did not cooperate with that adventurous spirit. He slipped, fell hard, and broke his leg. An ending that sounds perfectly reasonable for a bad decision. But a few months later, things got strange. The homeowner received a court summons, not for doing anything wrong, but because his house was not safe enough. The intruder was suing him for injuries sustained while trespassing. And just like that, the homeowner went from victim to defendant. From that point on, a private home was no longer a place of refuge, but more like a liability-filled amusement park where every step has to be friendly, even to those who arrive with bad intentions. And the remaining question is this: if you are responsible for the safety of an intruder, does ownership really mean anything anymore? Story 2. Catching the right person but the wrong way. In this story, the police actually do their job seriously. They surveil for days, connect the clues, review camera footage, cross-check timelines, and finally piece everything together into a complete picture. This is the kind of case where everyone thinks the ending is already written. Then the key evidence appears, an undeniable item sitting exactly where it should not be. The investigators breathe a sigh of relief. The suspect is arrested, lawyers are called, and everyone believes justice is about to do its job. But there is one small problem. One procedural step is done incorrectly. One paperwork detail is not perfect, so small that no one notices until they are standing in court. And there, that tiny detail becomes more powerful than all the truth combined. The judge throws out all of the evidence, not because it is wrong, but because it was collected the wrong way. The guilty person walks out of the courtroom legally free, leaving behind the feeling that, in this world, the method sometimes matters more than the outcome. Story 3. Community security or a suburban nightmare. This family lives the textbook American suburb life. Neat house, perfectly trimmed lawns, neighbors so friendly that everyone believes nothing bad could ever happen here. A place where the biggest problem is usually putting the trash out on the wrong day. Then one night they notice a stranger lingering around their house. Not a delivery driver, not a neighbor, and definitely not someone out for a late night stroll. Feeling uneasy, they do a very normal thing. They call the police. The police arrive, the stranger disappears, and everything seems to be over. But a few days later, the family receives a letter from the homeowners association. Not a thank you, but a fine. The reason they called the police without going through the neighborhood management first. From that moment on, safety matters less than procedure. Civil rules side with internal regulations, while the right to live in peace gets squeezed under a pile of paperwork. And the question that remains is this: if you have to ask for permission before being protected, then community security is really for whom? Story 4. Occupying a house with the law on their side. The story begins with an empty house. The owner moves elsewhere thinking that in a few years everything will still be exactly the same. The house stands there silent, its American dream left unlocked, accidentally sending out a dangerous signal. No one lives here. Then a stranger appears. At first, he just sleeps there temporarily. Later, he moves his belongings in, fixes the plumbing, mows the lawn, hangs curtains. Little by little, he lives there as if he has always belonged to the place. Years later, the real owner returns with an old key and a brand new sense of shock. But instead of being welcomed, they get hit with a hard truth. The court sides with the person currently living in the house. The law does not ask who bought the house, it asks who has lived there long enough. In the eyes of the law, time becomes proof of ownership. And the uncomfortable question that follows is this: if you are gone for too long, is that house still really yours? Story 5. Watching a tragedy legally. The accident happens right in the middle of a public place, at a time when everyone is around. One person suddenly collapses. The pain is obvious. Not the kind of fall where someone shrugs it off and says sorry. This is the kind that makes the whole crowd stop and stare. And they do exactly one thing: they watch. Some people step back just to be safe. Some pull out their phones. Some assume someone else will help. A minute passes, then another, and no one bends down. No one calls emergency services, no one touches them, no one intervenes. The hard-to-believe part is this: in many cases the law completely allows it. You didn't cause the accident, so you have no obligation to help. Standing still, watching, walking away. None of it breaks the law. The law doesn't call this heartless, the law calls it no legal duty. And that cold distinction is what turns indifference into a legally protected action. So the final question is this: if the law allows you to turn your back, then what if anything forces you to turn around? Story 6. Same crime, two very different fates. Two men commit the same crime, in the same city, on the same day. Their case files are so identical that if you swapped the names, no one would notice. But their stories split almost immediately. The first man has money. Not much emotion, just a lot of numbers in a bank account. He posts bail, signs a few papers, and walks outside to breathe free air. That night he eats dinner at home, sleeps in his own bed, and waits for his court date the way you wait for an uncomfortable appointment. The second man doesn't have that money. He also waits for his court date, but he waits inside a crowded, noisy, cold-holding cell. Not because his crime was worse, but because his wallet was lighter. Before the court ever decides who is guilty and who is not, the system has already delivered a different verdict. Freedom, it turns out, is not free. It has a price, and not everyone can afford to pay it up front. Story 7. Sorry to the victims, I'm keeping the assets. This story begins with a carefully executed financial scam. Polished documents, smooth promises, returns that sound reasonable enough to make everyone think this is the opportunity of a lifetime. Then everything collapses. The money disappears. The victims lose everything: savings, retirement funds, and any remaining faith in people. The main character doesn't disappear. He simply files for bankruptcy. Legally, with lawyers guiding every step. On paper, he has nothing. In real life, he still lives in his house, still keeps his retirement accounts, still continues a fairly comfortable life. The law calls this basic protection so a person can start over. But to the victims, it feels like watching someone apologize very politely while still holding the key to the safe. Justice has been served. It just never reached the money. And in this world, that is usually the most important part. Story 8. When privilege becomes a legal defense. The main character in this story is a young man born into extremely comfortable circumstances. A wealthy family, an easy life, never worried about rent, never worried about utility bills. His entire life has been padded with credit cards and the phrase, "you're still young." Then one day he causes serious harm. Not a small mistake, not a misunderstanding, a real action with real consequences that someone else has to carry. When the case goes to court, everyone expects a fitting sentence. But the lawyer presents a rather unusual argument. He was too sheltered to fully understand the consequences of his actions. Too rich, too protected, too far removed from real life. And surprisingly, the law accepts that argument. So privilege stops being just an advantage in life and becomes a legal shield. And the hard question to swallow is this: if not understanding consequences because life was too comfortable counts as a mitigating factor, then who exactly is responsible for that ignorance? Story 9. The lawyer doesn't need to win, just stall. This case is fairly complicated, thick files, endless details, and everyone knows that if it ever goes to a serious trial, the chances of losing are very high. But the defendant's lawyer isn't worried. He doesn't need to prove his client innocent. He just needs time. So the requests for delays begin, one excuse after another. A witness is unavailable, documents need further review. The lawyer has a scheduling conflict, the system is busy too. The trial gets pushed back again and again. Time keeps passing, patiently. And then one day the lawyer smiles. Not because of new evidence, but because the clock has finally run long enough. The statute of limitations has expired. The case ends not with a verdict, but with a very cold period. In this situation, the law is no longer an obstacle. It becomes the most loyal ally of waiting. Story 10. When a typo defeats justice. Everything starts by the book. The police request a search warrant. The judge carefully reviews the file and signs it. The paperwork is valid. The seal is clear. Everyone thinks this is a case done by proper procedure. The search goes smoothly, and the results are obvious. The evidence is solid, undeniable. Then, someone reviews the paperwork again. A small detail appears, very small. An address is off by one number, or a date is off by a single day. Not wrong in spirit, just wrong in writing. But in the legal world, words are king. In court, that tiny mistake suddenly outweighs everything else. All the evidence is thrown out, not because it's false, but because it was found under an imperfect piece of paper. The case collapses because of an error smaller than a bullet. And people realize that sometimes justice isn't defeated by the cleverness of criminals, but by a typo. Story 11. A confession erased by one sentence. The defendant in this story does the one thing every lawyer fears. He confesses. Not a vague admission, but hours of talking. He explains everything in detail, clearly. He even corrects himself when something isn't clear enough. If the truth had a shape, it would be sitting right there on the video recording. The problem starts a few minutes earlier. In a tense moment, the police officer reads the Miranda rights incorrectly. Not the meaning, just the order. One sentence missing, one sentence said too late. Very small, very human. But in court, wrong is wrong. Hours of confession become meaningless. The court refuses to accept anything said after an imperfect opening sentence. The result, the truth is erased by procedure. Not because it wasn't real, but because it was spoken after one sentence said the wrong way. And people realize that in this system, how you start sometimes matters more than everything that comes after. Story 12. A serious crime disappears in a deal. In an ideal world, justice looks like a formal courtroom where the truth is laid bare and the guilty are held accountable. In the real world, justice often looks more like a quiet negotiation. The prosecutor and the defendant sit down together, not to argue right or wrong, but to discuss what parts can be ignored. The defendant agrees to plead guilty to a lesser charge, something like, "Yes, I did it, but only a little." In exchange, the more serious accusations are neatly placed in a drawer and never brought to trial. No jury, no dramatic climax, just signatures and a nod. The system likes it because it's fast, clean, and saves time. The defendant likes it because the risk drops significantly. The result is this: the serious crime disappears before it's ever named. Justice is still done, at least on paper. And people realize that sometimes justice isn't enforced. It's negotiated. Story 13. Committing crimes on a subscription plan. The person in this story is not an impulsive thief. He is disciplined. Every day he walks into the same store and takes one small item. Not much, not greedy, just enough to stay below the serious criminal threshold. The law, it turns out, really likes to split things up. Each theft is treated as a separate incident. No adding things together, no monthly total, no box labeled total damage so far. So every day he commits one small offense, and every small offense is handled very lightly. Day after day, the small items pile up into an entire stash. But on paper, it's still just a long list of minor violations. No major case, no heavy punishment. This is where crime starts to look like a monthly subscription. Pay a little, pay regularly, and always stay inside the safe zone. And the uncomfortable question is this: if the law rewards patience more than it punishes the total harm, then who is really learning a lesson from that? Story 14. When violence is signed by both sides. This story begins with a very simple verbal agreement. Two adults, sober, facing each other, and mutually agreeing that today is a good day to fight. No one is forced, no one is caught off guard. Everything happens voluntarily, like agreeing to play tennis, just without the rackets. The punches are thrown, blood may be spilled, neighbors may record videos, but legally the law steps aside and watches. Because if both sides agreed, this is no longer considered an assault. It is a consensual conflict. There is no clear victim, so there is no one the law needs to protect. The law does not intervene like a referee who put the whistle away before the match even started. And just like that, stupidity becomes legal. The remaining question is this: if two people agree to do something dangerous to each other, should the law stop at respecting freedom, or should it step in to protect them from their own bad decisions? Story 15. The instinct for freedom is not considered a crime. One day a prisoner decides that today is a perfect day to not be in prison anymore. Not through violence, no attacking anyone, no serious destruction. He simply finds a way out and runs. Very fast, very determined. When he is caught again, everyone assumes he will receive an additional charge. But no, surprisingly, the act of escaping in some legal systems is not considered a separate criminal offense. There is no extra punishment just for trying to escape. The law explains this calmly. The desire for freedom is a natural human instinct. No one likes being confined. Trying to escape in a certain sense is understandable. Of course, if he commits other crimes while running, that is a different story. But the act of trying to break free itself is met with legal understanding. And so sometimes escaping is not treated as a crime, but as a very human reaction. The question remains, if the law understands that instinct, then where exactly is the line between compassion and indulgence? Story 16. The right to stay silent and everyone understands. The defendant stands before the jury, lights aimed straight at his face. The courtroom so quiet you can hear chairs creak. The prosecutor asks a very simple question, and also a very dangerous one. The kind of question where answering honestly would end everything. The defendant thinks for exactly 1 second, then chooses the oldest legal strategy there is. He says nothing. No denial, no explanation, no story about a difficult childhood. Just silence. And the strange thing is, the law fully protects that choice. The jury is not allowed to think that this silence means guilt. On paper, they must pretend they heard nothing at all. Silence suddenly becomes a perfect shield. Everyone understands the message behind it, but no one is allowed to mention it. And so justice moves forward carrying a truth that everyone can feel, but no one is allowed to say out loud. Story 17. When the truth never reaches court. In this story, the person who committed the crime does something genuinely honest. He confesses to everything. No dodging, no downplaying, no blaming circumstances. But he does not confess to the police. He confesses to a priest in a quiet room with no microphone and no written record. In this case, the law chooses to stay out of it. The priest cannot be forced to testify about what he heard. No subpoena, no exceptions. The truth is fully spoken, but it exists in a place the legal system is not allowed to touch. And so the secret is buried forever. Not because there is no evidence, but because the evidence lives inside a conversation that the law protects absolutely. The law calls this the protection of religious faith. But to society, it feels like watching the truth walk into a locked room, the door closes and it never comes back out. And the remaining question is this: if the truth is spoken but cannot be used, does it truly exist within justice at all? Story 18. The one who knows everything is allowed to stay silent. In many crime stories, the person who knows everything is the most important witness. But in this story, the person who knows everything is the defendant's spouse, husband or wife. Two people who live together, share everything, from Wi-Fi passwords to secrets that should never be said out loud. When the case goes to court, the prosecutor wants their testimony. Badly. But the law shakes its head. A spouse cannot be forced to testify against the other about things shared during the marriage. Not because they know nothing, but because they know too much. The law calls this the protection of the sanctity of marriage. Trust between two people is placed higher than the court's need to uncover the truth. And so the person who could explain everything most clearly is given the absolute right to remain silent. The result is that justice has to move forward, missing its most critical piece. And the uncomfortable question is this: if the law chooses to protect relationships over the truth, then where exactly does the truth go? Story 19. As if it never happened. There are things in life people wish they could erase the way you erase browser history. In this story, the law actually allows it. A criminal record is erased. Files are sealed. On paper, everything disappears cleanly as if it never existed. The person who once committed a crime steps back into the world with a brand new start. When applying for a job, they can answer no to questions about a criminal record. When renting a home, no trace appears. To everyone around them, they are a completely ordinary citizen. No past, no blemishes. The law calls this a second chance, a very humane idea. But the strange thing is, the past doesn't truly disappear. It's just hidden. The people who might be affected in the future have no idea whatever happened before. And so the law chooses forgetting on behalf of society. The question that remains is this: if the past is erased from the record, but still fully alive in the memory of the person who lived it, then who exactly is being protected? Story 20. When the trap goes too far and the price it costs, this story begins with a very determined police operation. They want to catch a criminal, and they want to catch one for sure. The problem is, to do that, they have to help someone find a reason to commit a crime. An ordinary person is approached. The first offer is small, then more tempting, then slowly crosses a line. Step by step, the line keeps moving. Eventually, the person does something they never intended to do before. Not out of greed, but because they were pushed one step at a time. When the case goes to court, the prosecutor presents all the evidence. But the defense lawyer asks just one simple question: without this encouragement, would the act have happened at all? The court pauses, thinks, and sides with the defendant. Not because the act was right, but because the method went too far. The law calls this entrapment. And in the legal world, how you catch someone sometimes matters more than who you catch. Story 21. Insane or not responsible. This story begins with a serious criminal act. No ambiguity, no confusion. The consequences are real and severe enough to make the entire courtroom fall silent. To an outsider, everything looks clear. There is an action, there is harm, and there is one person who appears to be responsible. Then the lawyer stands up and asks a different question. At that moment, did his client truly understand what he was doing? Could he distinguish right from wrong? Or did his brain make the decision instead of reason? The law calls this a defense of mental incapacity. If it is accepted, the story takes a different path. Not prison, but a psychiatric hospital. Not punishment, but treatment. It sounds humane, and sometimes it truly is. But the discomfort remains. When someone causes serious harm, yet bears no criminal responsibility, the question is no longer where they are sent, but where justice stood throughout the entire process. Story 22. When will does not control action. In this story, the issue isn't motive, but control. A dangerous act occurs, real harm is done, and everyone wants to know why. The answer is this: the person never intended to do it. Their body acted before the brain had time to give permission. The law calls this an involuntary act. It can be caused by a medical condition, a reflex, or a disorder that puts the person on autopilot. No thought, no choice, no moment to weigh right and wrong. Just a body doing what it does. When the case goes to court, the question is no longer, what did he do? It becomes, did he have control? If the answer is no, the law is willing to nod in understanding. It sounds like science fiction, but it is completely legal. And so, in some cases, responsibility is not removed because someone is innocent, but because no one was truly at the wheel. The final question is this: if will does not control action, then what exactly should the law be judging? Story 23. When a logo shields people. This story begins with a company. Not a specific person, but an entity with a name, a logo, and its own legal department. That company causes real harm. The people affected are real too, with real bills and real consequences. When the case comes to light, all eyes turn to the people who made the decisions. But then the law steps in and points to a different name. Not the CEO, not the managers, but the company itself. The legal entity takes responsibility instead of the humans. The company is fined, the company is reprimanded, the company may shut down or change its name. But the individuals who signed the decisions, who nodded and let it all happen, none of them go to prison. The law calls this the separation between individuals and a legal entity. But to outsiders, it feels like the logo spread its arms to shield the people standing behind it. And the uncomfortable question is this: if only the company is punished, then who is really learning anything from that mistake? Story 24. When telling the truth destroys your career. The main character in this story is not a criminal. He's just an ordinary employee, works hard, does his job, and accidentally discovers that his company is doing something wrong. Not vaguely wrong, wrong enough that if it came out, everything would explode. The problem is he signed a contract. A very thick contract, very formal, with a small clause called confidentiality. That clause says one simple thing: if he speaks, his career ends, immediately. When the issue comes to light, the law does not stand on the side of truth. The law stands on the side of the contract. The company has a team of lawyers. The employee has one very clear choice: stay silent and keep his job, or tell the truth and lose everything. So the truth gets locked away by perfectly legal paperwork. No one has to silence him. The law already did that part. And the remaining question is this: if telling the truth makes you the one at fault, then what exactly is this system really protecting? Story 25. A reward for the traitor. In the criminal world, loyalty is talked about loudly. But when the law steps in, loyalty becomes a rather flexible choice. A criminal is caught and faces a heavy sentence. Then the lawyer whispers a simple suggestion: if you know something, now is the time to remember it. So the criminal switches sides. He informs on his partners, details everything, every action, every name, every meeting. In return, the state offers a very attractive reward. Not money, but legal disappearance. He is protected, given a new identity, moved somewhere else, with a new name and a new life. Yesterday, a criminal. Today, just some friendly neighbor in a quiet town. The law calls this an effective way to dismantle criminal organizations. But the feeling is still strange. When the traitor is given a brand new life, the remaining question is: this is justice punishing crime or rewarding the fastest betrayal? Story 26. Zero tolerance policies in schools. This story begins in a very familiar way. A child goes to school every day with a backpack heavier than it should be. Not because of books, but because of fear. They are being bullied, not once, but over and over again. Teachers are told, the school is informed, everything is documented very politely. Then one day the child fights back. Not to attack, but to defend themselves. A shove, a sudden reaction meant to stop being cornered. And that's when the system moves fast. Under zero tolerance policy, both students are punished equally. It doesn't matter who started it. It doesn't matter who endured it longer. The rules like simplicity, and the simplest option is treating every hit as the same. The result is that the victim learns a very clear lesson. Defending yourself can still get you in trouble. And in trying to be fair to everyone, the system accidentally flattens a pain that was very real and very complex. Story 27. The past disappears when adulthood begins. When you are a minor, you are allowed to make mistakes, at least in theory. That's why the system creates something called a juvenile record. It documents everything that went wrong, but only temporarily. At a certain age, that record is automatically sealed. No request needed, no explanation required. On paper, the past is neatly folded and placed in a drawer no one is allowed to open. The moment you become an adult, you officially become someone who has never done anything wrong. Society doesn't know who you used to be, employers can't see it, neighbors don't know, even the people who trust you most have no way to access that information. The law calls this giving youth a second chance. It sounds like a beautiful idea. But sometimes the past isn't just a mistake left behind. It's a warning sign. And when the law chooses to forget on behalf of society, the remaining question is this: who is being protected more, the person who changed or the people who never got the chance to protect themselves? Story 28. When emotion beats the law. In this case, everything seems painfully clear. The evidence is complete. The testimonies are consistent. The chain of events is so logical that if you drew a diagram, it would only need one arrow. The defendant, at least on paper, is clearly guilty. Then it's the jury's turn. 12 ordinary people, bringing their emotions, their life experiences, and a few bad days along with them. They listen to the law, they listen to the facts, and then they listen to their own feelings. Someone feels sorry for the defendant. Someone doesn't like the prosecutor. Someone just thinks the law feels a bit too harsh in this situation. And so, despite what is clearly written on paper, the jury says no. The law isn't overturned. It's simply pushed aside in the moment when people decide their emotions matter more than legal clauses. The defendant walks free, not because he is innocent, but because 12 people didn't feel comfortable finding him guilty. And the remaining question is this: when justice depends on collective emotion, how strong is the law really? Story 29. Justice as a lottery. Two cases happen in the same city. Two defendants commit the same crime. The circumstances are almost identical, so similar that if you swapped the names on the files, no one would notice a difference. In theory, the outcomes should be the same. But in reality, they aren't. The first case lands in front of a strict judge. No patience for excuses, doesn't like detours, reads the law before morning coffee. The sentence is heavy, decisive, applied line by line exactly as written. The second case is handled by a different judge. More empathetic. In a good mood that day, the lawyer presents the case well. The result is a much lighter sentence. Nothing in the law changed. No new evidence appeared. Only the human changed. And just like that, the same crime splits into two completely different futures. The law tries to be fair, but when humans are the ones enforcing it, justice sometimes looks less like a precise system and more like a lottery ticket. Story 30. A sentence that never touches the money. When someone is convicted, people usually imagine a clear punishment. Prison, probation, some kind of price that matches the crime. But in this story, the most important thing is not the sentence. It's where the money is. Before everything collapses, the main character is very careful. The money is moved into asset protection trusts, legally owned, structurally designed to not belong to him on paper. In the records, he looks poor. In real life, he isn't. When the court delivers its verdict, the punishment is fully enforced. But the money stays exactly where it is. No seizure, no touch, no pain. The law calls this legal financial planning. But the feeling it leaves behind is deeply uncomfortable. When a sentence can't reach the assets, the punishment suddenly feels very light. And the remaining question is this: if you keep everything that matters most, were you ever really punished at all? Story 31. The law protects freedom and those who abuse it. All the stories before this, no matter how strange or uncomfortable they were, circle back to the same central principle of modern justice: the presumption of innocence. A concept that sounds very simple. You are innocent until proven guilty, not the other way around. That means the burden of proof is not on you. You don't have to explain that you're a good person. You don't have to prove you did nothing wrong. The state has to do all the hard work. And if there is even the smallest gap of reasonable doubt, you are free to stand up and walk away. This principle was created to protect people from power. But precisely because it is so powerful, it becomes the perfect hiding place for those who are patient enough, knowledgeable enough about the law, and equipped enough to exploit it. The law does not ask who deserves protection and who does not. It simply follows its own rules. Final reflection and literal translation with pauses for voice narration. The presumption of innocence is a necessary right. Without it, anyone could become a victim of power. But that protection comes with a risk that society has to accept. That sometimes the person who did wrong will escape responsibility. Not because they were right, but because the system was designed to prioritize freedom over certainty. The law was never born to be perfect. It was born to limit power and protect people. And in doing so, it will always leave gaps behind. So, the final question for you is this: should we try to create a perfect legal system? Or should we accept that the law has limits and that what matters more is whether people understand those limits well enough not to abuse them?